Friends, uh, in our journey of sharing knowledge, we begin today, and we all understand that knowledge prospers all. Today, friends, in our episode on case analysis, we are going to discuss some cases regarding absenteeism. Friends, now we see the second case law, that is Deepak Bhimraj Kamble versus Kirloskar Oil Engines. Well, friends, in this case law, the issue was as to whether an application is made, and if at all it is made, whether the application has been rejected or the leave has been granted. Sometimes workmen are very funny. Somebody gives a phone call. I'm going on leave, proceeding on leave right now, grant me the leave, anything. Basically, this leave application has to be in writing. And an application has been filed, but then who is going to see as to what is the fate of the application, whether it is accepted, whether it is rejected. And then a mere filing of the application, the Honorable Court in this judgment says, is not enough. You have to understand whether your leave is allowed or it is rejected. And if it is not rejected, you have to be present on duty. And this accepting your application or rejection of your application depends on so many factors. How much is the total workforce today? What is the work at hand? Timely projects are needed. Time frames have to be adjusted. You have to see as to what are the deadlines. Depending on this, the HR manager or the company officials will either grant the leave or they may not grant the leave. But then whose duty is it to see? The workman says, I threw the application and vanished. Is this the attitude you are going to exhibit? No, that is certainly not what is the mandate contained in this judgment. Now you see in this judgment, the judge says an employee can offer proper explanation to convince the employer that he was precluded by compelling circumstances from filing a leave application. That is allowed. What are the circumstances? So many circumstances. There was nobody in the house. Only myself, my wife and my small child. Who's going to give the application? Why? There was a serious emergency situation. There was an accident. Somebody was to be taken to the hospital. All of these could constitute valid reasons, and no employer is also supposed to be stone-hearted. He is not supposed to be ruthless, unmerciful. No. He has to think not only by the brain but by the heart also before accepting or rejecting any leave application. And it is from this angle the apex court, that is the Honorable Supreme Court of India, dealt with the issue of willful absence. Its absence qualified by an adjective, that is willful, voluntarily, suo motu, on my own, I am absent. Now, when an employee absents from duty according to the Supreme Court, he prima facie shows a lack of interest in work. There are some people who are absolutely not interested. He is only interested in his paycheck. And that too, if he doesn't get in time, he'll cry his heart out. Question is, you are here for what? You are here to work. And if you are here to work, that's the only answer. You have to work and he is going to pay you. And if you are not working, that what does it exhibit? It exhibits some features of disinterest in work. Then the Honorable Court further says that habitually negligent in duties and exhibiting lack of interest in the employer's work. Again and again you are doing the same thing. You are habituated. So it's a habitual negligence also as far as your duty is concerned. How should you be doing your duty? You should be diligent. Your basic purpose is to attend duty because that is your bread and butter. This is what some workers fail to understand. And of course, there cannot be a sweeping generalization. There are good workers, there are bad workers. And then I'm not going to pinpoint each and every worker. Some are, say, in the words of an honorable judge of the English courts, wherein he said that there are two types of people. Some are very timid and some are the nonchalant ones. Nonchalant means in the vernacular bindas. The timid ones think that every path is beset with lions, and the nonchalant people are not even afraid of the most obvious danger. What happens if I don't give the application? What I will not see as to what is the leave to my credit? He is not bothered. And that is why of course, there are some workers who are very diligent, who all the while think in terms of the welfare of the company. And then you have the employer also has to think, as I said, not only with the brain but with the heart also. His past record also is to be seen. Emergency situations are to be seen, and that is why there cannot be a sweeping generalization in the words of the Honorable Apex Court. At the same time, there are some telltale features which can be noticed and pressed into service to arrive at conclusions in the departmental inquiry. Now, this will of course depend on time, place and circumstance. So it cannot be a straitjacket formula 2 plus 2 is equal to 4 and here he is absent and here is the punishment. No, you have to delve deeper into it. You have to understand the gamut of the total thing. You have to understand the context also, in the words of the Honorable Supreme Court in this judgment. Yes, friends. Now we'll see another case, that is Dayanand Paswan versus Coal India Limited. And in this case, the Honorable Court states that an employee cannot, as a matter of right, claim leave of absence. He says, I want leave. There are 20 leaves to my credit. But can he claim it as a matter of right? No, you have to see the exigency of the situation. You have to see as to how the company is going to function. You have to see as to availability of manpower, timely projects, deadlines, everything is to be seen. Just because you have a leave at your credit, there are 40 people in the company who have leave at their credit. Does it mean that all these 40 workmen can go home at the same time? The answer is a simple no. And then there might not be an application for the same also. Some people are, well, I am having a leave to my credit, so why should I give an application? This sort of a behavior, remember friends, is not tolerated. No worker is to take the leave to his credit for granted. Just because the leave is to his credit, it doesn't mean that the leave is granted. You have to yet file an application and see and ensure whether the leave is granted or not. Now, the Honorable Supreme Court in Chennai Metropolitan Water Supply Sewerage Board and versus Murli Babu, this is another landmark case. It's in a way a cardinal principle of law or a canon of jurisprudence or a jural fundamental, you can say, very elegantly articulated in this judgment, wherein the Honorable Judge writes that, well, it does not, what does it tantamount to? You are again and again absent. It amounts to, or tantamounts to, tantamounts to devotion of duty, failure for devotion of duty. That is the phrase which is yours. You have come here to work, then you devote yourself to the work. It's failure to devote yourself to the work. That is failure for devotion to duty. And it's behavior which is unbecoming of a servant, whether it's public enterprise, whether it's a private enterprise, whether it's a government enterprise. You are here to work. Again and again you are being absent. Sometimes we have visited government offices just to see that some clerk in on a specific table is again and again absent. In such cases, the Apex Court has held that he is unbecoming of a government servant. You should know the employer should take pride in his worker, and the worker is there to give proper service. Otherwise, it tantamounts to failure of devotion to duty. You should be absolutely devoted. Employer is giving you 100% payment and 100% salary. So what about your 100% devotion? That is the point, friends. Then in another landmark case, friends, again a jural fundamental, very elegantly articulated, and that's why I'm mentioning this case, is that is State of Punjab versus Dr. P.L. Singla. That is another case in which unauthorized absence or overstaying of leave is an act of indiscipline. First is you are unauthorizedly absent, and then you are, for example, come on, let's presume that your leave is granted for 10 days, but you overstay the leave. Or you should be reporting on the 11th day. Instead, he goes for a further 5 days more, no application, nothing. And this is an act of indiscipline. Don't you believe in discipline? And whenever there is an act of unauthorized absence by an employee, two courses are available to the employer. One is either to condone or to proceed against him. Why are you absent? The misconduct spelled out in the model standing orders is 10 consecutive days. If he is absent, then he commits a misconduct. On the 11th day, but of course, as I told you, we are going to think not with the brain, but with the heart also. On the 11th day, if you start terminating people, half the India would be on the roads. So that cannot be done. And then the doctrine of proportionality, there should be a sense of proportion, does not even get remotely attracted is what the Honorable Judge is saying, to such cases, and punishment is not shockingly disproportionate. You are habitually absent. Again and again you are absent. No application, unauthorized absence, overstay of leave. So in such cases, doctrine of proportionality is not remotely attracted and punishment is not shockingly disproportionate. Of course, the absence, remember friends, has to be a sizable one. On the 11th day you terminate people. Well, that cannot be, because ultimately the edifice, the substratum, the foundation of all labor law is social justice. We are here not to drive away people home. We are here to respect their rights, and at the same time we are here to understand the rights of the employer also has to be respected. Okay, and that is why a balancing of this is ensuring discipline. Yes, friend. Now you see, we'll see a few more cases and then we'll stop. The question is Om Prakash versus State of Punjab. Now in this case, the appellant was absent for a period of 39 days. Many a times, how much? Say 10 consecutive days, understood. So on the 11th day, you do commit a misconduct. But then people, I mean, it's in the fitness of things that one is not to be removed just because it's one day more. Then what is the safe figure? In Abba Shelke's case, we discussed that 1 month, no lenient punishment can be given. So he is absent for 1 month and no leniency. In this case, this appellant was absent for 39 days, and then the court said that yes, he reported back after say 39 days, and at this stage he did not produce any document. Where were you? In India, history is very important. So you are absent for 39 days and you are not coming with a document, not a medical certificate, nothing. If at all you claim you are ill, then the onus is on you, the burden of proof is on you to understand. And nothing was produced to indicate that he was admitted in a hospital as he was claiming. And then ultimately he was punished with capital punishment, that is a dismissal. Then friends, we are having T.K. Rajan versus Labour Court. That is another authority wherein the leave applied by the petitioner was not sanctioned, and the leave of, again the court held that this cannot be treated as a matter of right. You cannot take leave as a matter of right. Remember friend, the common thread which is going on in all the judgments is leave is not as a matter of right. You have to give an application, wait and see if it is sanctioned, and only sanctioned leave will become is leave actually. And then lastly, we see Dr. Leela Agarwal versus State of Himachal Pradesh. In this case, it so happened that the petitioner remained willfully absent from duty from time to time for a considerable period without well-founded reasons. What happens to your industry is one part of it, but production is hampered. And what about manpower planning? Manpower planning is a management function. So the management relies on you, gives you salary, pays you, and again you are absent and absent and absent. So this will not be tolerated, is the mandate of these judgments. And friends, we just took in this episode 3-4 judgments, or perhaps a bit 1 or 2 more, just to understand as to what is the law involved in this. And moreover, a common message which comes is that discipline will not be tolerated, absenteeism will not be tolerated. Yes, you can avail of leave, but then there's a methodology. You have to follow that method, and then you can avail of leave. Okay. Yes, friends. So this brings us to the end of this case analysis episode. And in our journey to share knowledge, both you and me are students. So we wait for another episode to just give food to our minds, because knowledge prospers all. Yes, friends.